And I'll use an example of a case that I was involved in. It was a case between two lenders where one of the two had an obligation to go out and inspect the collateral. In this case, it was a loan to a rancher out in California who had 10,000 cattle, and those were collateral for the loan. So if he defaulted, our client could go in, take all the cattle, sell them, and get their money back. The other lender that we were co-lending with had contractually agreed to do all of the work of inspecting the cattle and making sure they're there. They were supposed to send someone out every month, count the cattle, make sure they were there, so we knew if anything funny was going on. Lo and behold, the guy declares bankruptcy. They go out. There's supposed to be 10,000 cows. I think there's like 300. So we end up in a dispute over who needs to take the loss on this. I think it was like a $6 or $7 million loan to this guy. Now, when I'm going through the facts section and talking about whether the co-lender did their job of inspecting the collateral and making sure it's there, I am highlighting every failure that they had to go out and look at the cattle. If the guy just kind of went out there and just kind of glanced at, it seems like there's maybe 10,000, we highlighted that that's not enough. He wasn't doing his job. He wasn't there on a regular basis. He didn't have any experience doing this. He had a conflict of interest because his company was also selling products to this rancher. So we really focused on the facts that support our desired outcome. So I'm going to highlight all of their failings. Now, if there's something where it would indicate that my client maybe should have known what was going on, I'm not going to bring that up because the other side gets a response brief. And at that point, they're going to make all the arguments and present all the facts that would tend to indicate that my client didn't come in with clean hands. You don't have, you can't misstate the facts. You can't lie about what the facts are. But you also don't have an obligation to tell the court about every fact that cuts against you. It's a little bit different than the law, right? If there's a case that directly cuts against you and you know about it, you have an obligation to present it and distinguish it. But you don't have to highlight every single fact that indicates that the court may or should rule against you. The other party, we have an adversarial system, and the adverse party has the obligation to bring up those facts to defend their interest.
So let's say there is a bad fact, and you know that in their response they're going to bring it up. You don't want to bring it up before they do, just to set the light, or do you wait till they say it first?
It's a very good question, and it's something that you will wrestle with. If there's there's obviously varying levels of bad facts. There's some that will come across as they're grasping at straws to try to find something to help them out. Yeah. But there are ones that might be deal breakers for you. In those facts, I think I tend to try to address them up front. So you don't have the obligation to do it, but you have to worry about credibility with the court. And if there is something that just absolutely cuts against you on a factual basis, and you don't discuss it in your opening brief, the court is not going to be particularly happy. So it's a tough decision, and it's tough to figure out how to do it.
And it's important to know that, if it is a really bad fact, I represent a client that owes $600,000 in a contract dispute, and there's no way around it. He owes over $500,000, and we've been before a federal court 3 times now on this case, and the underlying issue here is my client owes a lot of money, and there's no way around it, and so I address it when I write my briefs. But how you can address it, and I think this will go to your question, is you put it in the middle of a paragraph, right? So your bad facts and your bad law should always go in the middle of a paragraph, so that you can start that paragraph off with something strong. You can address it, and you can even address it in despite the longstanding nature of the parties, plaintiff's account grew in arrears in excess of $600,000, and then you move on right after that. But so you can fold it into the middle, and that way it seems like you're being forthright, but at the same time, kind of to Dave's point, it's not in your client's best interest to bang the drum on the bad facts throughout your brief.
I have a question about where you draw the line. You said you can't misstate the facts. So I'm wondering at what point you are misstating the facts, like making too many mental leaps. For example, I'm working on an appellate brief for someone in deportation proceedings, and during the trial, his daughter-in-law was pregnant, and she was due in November. So I can conclude that she had a baby, and the baby is a U.S. citizen, because I can't imagine that the woman would leave to have a baby out of the country. But I don't have anything that says that. And like, how far can you go making deductions from the facts that you have?
Well, I mean, like
crossing
in that
misstating
example,
the facts.
it's especially tough in the appellate arena because you're bound by facts that were entered into evidence below for the district court. So that's difficult. But if you want to draw an inference or make a presumption, you can do so by just saying presumably, the baby was born.
Right. Whenever I'm writing the fact section and I include anything that is not a proven or established fact, where I can cite to a transcript or a document, I indicate that I am making an inference or a presumption. The only possible conclusion that you can draw from the fact that Mr. Smith was at the ranch for 20 minutes is that he did not conduct an adequate inspection. So I can't say he didn't conduct an adequate inspection. That's not a fact that's established. But you can draw inferences from it, but you need to indicate that you're drawing those
But
inferences.
you wouldn't cite that inference, right? Like would you cite that he was only there for 20 minutes? Or would you just say presumably are the only way that you can?
I would cite the documents that indicate he was only there for 20 minutes. So, Mr. Smith, how long did you conduct the inspection? And he answers in his deposition, I was there about 20 minutes that day. So I write the brief, I say, Mr. Smith, when he conducted his inspection in January, was only there for one day. The only possible was only there for 20 minutes. The only possible conclusion you can draw from that is that he was inadequately carrying on his duties. So whenever I draw an inference, I cite the facts that lead to it. That's going to be more persuasive to the court. Right? The court is going to want to look and see the evidence that supports the facts that lead to the conclusion that you're drawing. I think we're going a little slow as I look at the clock. The clock's going fast. I'm sure it's the clock, not us. But the last thing I want to say about the facts is think about the order that you present them to. The tendency is to always go in chronological order. That's not always the most persuasive way to do it. You might want to start with, I'm thinking of this case that I mentioned, start with the fact that the guy ended up in bankruptcy and the cattle are all gone, and we had this agreement, and then you go back in time to discuss the relationship in the inspection history. And you get to the conclusion, and then you explain how you got there.
So the next section in your brief is obviously your legal analysis. Are you all 2 L's, 3 L's, 1 L? Oh, that's a 1 L's. Okay. So is your first legal writing assignment a memo?
Yeah, we did that.
We did our
second semester.
We're doing-
We have trial
Okay.
court briefs due Monday.
I already turned my first trial brief in.
Okay. So I mean, the big takeaway as you start brief writing as opposed to memo writing is the structure of your analysis section changes, right? So you in your first year of law school on your exams, the IRAC format is pounded into your head. It's the same general format when you're writing a brief, except that issue statement needs to be made in a conclusive or persuasive way. So I was always taught that instead of IRAC, it's crack. So it's conclusion, rule, analysis, conclusion, right? So it's especially important when you're writing to a judge. They don't want to read something that says, you know, the next issue is whether there's any material facts in dispute regarding whether or not the contract was truly, you know, executed. No, the contract was executed. Under Minnesota law, you know, we look to the formation of contract by, you know, these three elements. So you give your rule, you go in the analysis, and then your conclusion again is based on the foregoing. You know, there was a valid contract that was executed here. So don't miss an opportunity to make your point to the judge by simply giving a canned issue statement. And then, you know, that also leads to the conclusion. We'll try to speed up a little bit here. The conclusion, one of the biggest mistakes that people make in writing their conclusion at the end of a brief is just to say, you know, for the foregoing, plaintiff or defendant respectfully requests, you know, the relief as outlined above. Canned conclusions are the worst thing. One of the worst things you can do as an attorney for your client's money. I mean, if it's a canned conclusion, it doesn't add anything to what you've just written, right? It would be better off to cut and paste your intro and put that as your conclusion verbatim than it would be just to have a canned, you know, prayer for relief at the end. So recognize that conclusion is an opportunity, just like your intro, to sum everything up and put a nice little bow on it for the judge. And that's yeah.
So I'm laughing because in class yesterday, my professor said, you can just write for the foregoing, like everything you
Yeah.
just.
Right.
So can you talk a little bit about how different it was, like learning legal writing or legal practice in law school versus what you actually did when you get out and what was expected of you?
It's different in the sense that when you're actually advocating, when you're actually representing a client, it's a lot different than the academic experience in law school. I mean, you generally have gotten to know the client, know their predicament, and you feel a responsibility to them to truly, you know, put forth the best work product you can. Not that you wouldn't in law school, but it's different when you're gunning for a grade as opposed to, you know, when somebody's company is at stake, or if you're interested in, you know, immigration law, whether someone could be deported. So the fact that there's an actual face and a person to the client, I think has always mattered to me when I was writing.
Yeah, it was surprising how true that was, you know, in the first couple of years of practice, because you take law school very seriously and you work very hard in law school. But it's different when you have a client who their livelihood, whether they, you know, can receive political asylum and stay in the United States, whether their business is going to collapse and they're going to declare bankruptcy and their family has to sell their house. You know, it becomes different, and you know, for me, I'm competitive too, and I like to win, and that drives a lot of the brief writing too.
Right.
Is you want to win because you want to do it for your client, but you want to win because you want to win too. I mean, if you're a litigator, that's built into you somewhere.
So I mean, looking at what we were talking about in the conclusion, yeah, it's okay. I mean, you can just end with a canned prayer for relief, but is that the most effective way to make your argument? I would say that it isn't.
I mean, you can think of it this way: you've just spent 20 pages laying out your argument. Here's your chance in 3 or 4 sentences to basically give bullet points to the judge of key points that you make and why the court should rule in your favor. And you know, why would you want to miss that opportunity to reinforce for one final time why the court should rule for you? And this kind of brings us into, we're going to close with just some basic writing tips that we've picked up. And one that I think may have come through, but that I want to specifically mention is you want to develop a theme in your brief and tell the story. Make it interesting. As you can imagine with the case that I keep mentioning with inspection of cattle and contract between two big commercial lenders and loan documents. It had the makings for an incredibly boring summary judgment brief. But you can step back from it and tell the story about this rancher who kept getting a little bit too big. The company who was supposed to be lending to him was really happy making money and was willing to turn a blind eye. And you want to be able to just kind of tell that story in your fact section, in your intro, and then carry it through your argument too. That this is all about a company that was making a lot of money off these loans, so they had no incentive to go out and protect our interest by making sure the cattle were actually there. And that can come through in your argument all the way through to your conclusion. And odds are, if you're doing the oral argument, or if there's another attorney at your firm doing the oral argument, that's going to be the theme that carries through there. Or if you go to trial, that's going to be the theme. So build it early and give a lot of thought to it.
Another really important tip that we want to impart to you is shorter is better, and that goes for everything from overall length of your brief to length of your paragraphs to lengths of your sentences to length of your words. Something that I really learned when I clerked was that some of the most effective brief writers don't use big elaborate fancy words, and the same for a sentence structure. When I write, and this goes to Dave's point earlier about the importance of writing in a punchy manner, some of the most effective points you can make is, defendant is wrong. That's it. Defendant's argument fails. Defendant's theory is misplaced. Plaintiff's contention is unavailable. And those little 4 or 5 word, just quick uppercuts are really effective to a reader because they'll stand out within the overall brief as short, concise, and attention grabbing.
Yeah, it didn't occur to me until you just said it. 3-word sentences can probably be some of the most effective. Like you said, defendant is wrong. This is false. Because they're quick, punchy jabs. And if I'm reading a brief and I read the words, this is false, I want to know what's false. Why? Because if you're making that statement, I would never write that in a brief unless I was absolutely sure that it was absolutely false. And then you just get the pound on them with the following sentences of explaining what they ignored or what they're asking the court to ignore to reach that conclusion. So those quick ones, they're attention grabbers that will pull the court into the argument that you're about to make.
The other point that we want to make is you have an opportunity to make your argument in your headings and in the statement of issues. And as we touched upon when talking about the difference between an IRAC and a crack writing format, don't just have canned or unpersuasive headings. Like I had an appellate case I worked on last fall. This was one of the statement of the issues that was presented by the opposing party. Whether the district court erred when it dismissed home purchasers' claims for breach of contract, negligent misrepresentation, and fraud against the sellers, and held that as a matter of law, sellers in a residential real estate transaction are absolved from liability for the concealment of material defects and knowing failure to disclose the same on the basis that the purchasers could not demonstrate reliance on the seller's representations because the purchasers obtained a partial inspection of the property if the inspection took the position that the inspector was unable to discover the material defects due to the seller's concealment of the same. What does that mean?
Someone really wrote that?
Yeah,
Oh, wow.
that was actually submitted to the Court of Appeals, and I worked on the case, and I have no idea what they're talking about, right? So it's unbelievable. It's not even persuasive. I don't even know what the actual argument is that they were trying to make. So something like. Plaintiff had a duty to disclose the information and failed that duty. I mean, I think that's what they're trying to say, right? So just say it like that.
That's impressive.
It's something.
That is not what you want to do. Good legal writing takes a lot of time. When I write a brief, when you start out as an associate, it's going to be a bit of a transition because suddenly, in addition to representing real life clients, You're working in a business that needs to make money, which means you need to keep track of your time. Every minute that you spend working on something, you track it. And invariably, you're going to feel guilty as a beginning lawyer that you're spending way too much time writing a brief. So this has nothing to do with brief writing right here, but I'm going to give you some advice that's going to be very valuable to you. Keep track of every minute that you work on something. It's not your job to discount the time that you spend.
Yep.
If you spend 12 hours one day hammering out a brief, enter your time as 12 hours. If the partner who has the relationship with the client and reviews the bills thinks this person spent way too much time that day, they'll cross out 12 and they'll write 9 and reduce it. That's not your job. And it's going to affect how you're evaluated at your firm. Because although you're putting in 12 hours of work, if you only write down 9, they're going to think you only put in 9 hours that day.
And the other thing I'll add to that is, Dave's a partner, I'm an associate. So if we're working on a case together, if we, assuming we were at the same firm, he's charging a higher rate than I am, right? So part of the reason why associates often do the grunt work in the brief writing is because it's a cheaper rate. So don't feel bad about the time that you're spending, because you're expected to be able to require more time. Like I would be expected to require more time than Dave because he's got 5 to 6, 7 more years experience than I do, right? But it's assigned to me because it's cheaper and ultimately better for the client.
So now bringing it back to brief writing, it takes a lot of time to write a good brief. I think at a minimum, I spend an hour per page on a brief on the low end, and that's for a brief that is like a discovery motion where we want to get documents. If it's a summary judgment brief, it's probably 3 hours. By the time you add in reviewing the facts and reviewing the law and framing the arguments, rewriting, re-editing, it's probably easily, if it's a 20-page summary judgment brief, I probably easily spend 60 to 80 hours working on that brief alone. So be prepared that you're going to invest a lot of time in this. Edit your briefs. Edit them 2 or 3 times before you hand them off to someone else. And give yourself some time. If you finish your first draft of your brief, set it aside for 2 hours. Do something else, then come back to it and read it. For me, I have to print out my briefs and mark them up with pen. Because if I'm looking at the computer screen, my mind fills in words that are missing. It ignores misspellings, and I don't catch as much as I do. But take a lot of time to edit your brief. If you're writing for someone else, which you will be early in your careers, figure out what their writing style is and learn to write in the style that they write. It takes a little bit of time, but that's how I knew I was starting to really click with the group that I'm working with, is I would send a draft early on, and there would be as much red ink on the paper as there was black ink. And eventually it got to the point where there's just a couple sentences here and there that someone thinks should be reworked. You'll eventually figure that out and develop it. And a point on that too, accept criticism and accept constructive criticism because it's going to make you a better writer. So keep an open mind. Whenever I give a brief to an associate after I've reviewed it and they've written it for me, I always let them know, don't feel bad about all the red ink on here. I can go back to my office and show you the drafts that I did of my own work, and there's just as much red when I'm reviewing my own briefs as I'm giving them. So take the time to really invest yourself in brief writing. It'll pay off.
Yeah, I mean, the best legal writers don't have an ego. And the reason you can't have an ego is because if you're unwilling to accept criticism, then you basically become complacent and you're no longer striving to improve. So that's a very, very solid point. Embrace the criticism. It's tough for all of us to do because we're all type A and we've all come up through the same competitive filing, but it's important. And I think we should probably cut it off so you guys can get to the next one. But does anybody